Just mention that among my other educational attainments, I'm a graduate of Elgin High School, class of '58. Very proud of that. I'm going to be talking in really three sections tonight. First, about Kunstler, Bill Kunstler. His name was William, but he just insisted everyone call him Bill, so there's no point in calling him William. And a few remarks about him individually. Secondly, about the Chicago 7 trial. Particularly, I'd like to talk about my take on it and where I think Netflix film got it a little wrong. And then lastly, I'd like to talk more generally about radical lawyers in the 1960s and 1970s and how Bill Kunstler fit in with them. Kunstler is undoubtedly the most famous radical lawyer in 20th century America. Some might mention Clarence Darrow, but he really wasn't a radical lawyer. He represented a lot of notorious people, but he didn't have a political agenda. So he's not really, I wouldn't call him a radical lawyer. Kunstler had a very comfortable upper middle class upbringing. His father was a doctor. They lived on the Upper West Side of Manhattan. Their apartment was on Central Park West. Bill went to excellent schools throughout his entire upbringing. He went to Yale as an undergraduate and majored in French. He then joined the Army in World War II and actually was awarded a Bronze Star for his efforts during the war. Following the war, he came back to New York and went to Columbia Law School on the GI Bill and launched his career after graduation from Columbia in a fairly general civil practice from 1949 to 1961, much of that time with his brother. And he did just an ordinary civil matters like contracts and annulments and wills and trusts and things like that. And he was just extremely bored. He had so much energy. If you think of it, let's just take a look at the things that he did during those years of practice, general practice. He wrote hundreds of book reviews. He wrote for the book reviews for the Herald Tribune, and he wrote so many that they had to give him a pseudonym as well as his own name, so that it wouldn't appear to be sort of overlapping. He had radio shows. He at first was an announcer, but later he became the sponsor of his own radio shows. He wrote poetry. So, he wrote sonnets, actually, and it was in sonnet form, 12 lines followed by a couplet. And I can't say they're great poetry, but he put a lot of effort into them, at least. And it was something he thought he could do whenever he had a few extra minutes somewhere. He wrote books. Bill Kunstler was an author of 10 books. Some of the books are sort of collections of his other writings, but not all by any means. Many are very solid pieces. For example, he wrote a book on the Hall Mills murder case called The Minister and the Choir Singer. And it was not only such a good book that it was reviewed in the New York Times, but the New York Times included in their Sunday literary supplement. And on top of that, it was on the first page of the Times literary supplement. So that book had nothing to do with radical lawyering. It was long before really it started that, but it shows his talent and his need for creative outlets. In 1966, he published his memoir about his civil rights work in the South, and William Martin Luther King wrote the foreword for that book. In 1961, he was invited by the ACLU to be an observer at some proceedings in the South, and he began a civil rights practice in the South, which he kept up for several years, often just traveling across the South, often with another civil rights, left of center lawyer, Arthur Kanoy. And it was a very hectic, busy time. The basic theme of Bill Kunstler's approach to law and what he wanted to do with law was his fight against anti-Black racism. That was the cutting edge of his work. He thought the legal system was oppressive to Blacks, and that if he could defend them, even for a case that didn't have a conscious political motive behind it, he could bring out in trial and with the media and reporters the bias of the system in treating Blacks. So as the movement began to decline in the late 1970s and 1980s, his notion of oppressed classes expanded a little bit, and he included Native Americans within the group that was oppressed by the government. Muslims were oppressed by the government, and he took cases involving those groups too, making the point that regardless of the crimes actually charged, they were in fact victims of government oppression. Well, I'd like to start in on the Chicago 7 trial. Kunstler made an opening statement at the Chicago 7 trial that was based almost entirely on the First Amendment. The protesters on trial at the Chicago 7 trial had, of course, engaged in very vigorous protests the summer before, at the time of the Democratic Convention, which caused what was later termed the police riot. But anyway, Kunstler's opening statement was based on the First Amendment, that these people had the right to protest, blah, 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 and the First Amendment gives them that right. And as soon as they had opportunity, following the opening statement, the defendants just jumped all over him. They just didn't want a First Amendment defense. They didn't want to put themselves on trial, although technically they were the ones on trial. They wanted to put the government on trial. They wanted to show the American people the oppressiveness of the American government in general, and specifically oppressive in terms of Vietnam, which was the major point of the protest the summer before. And like a good radical lawyer, Kunstler deferred to the strategy agreed upon by the defendants. It was they were in the driver's seat. That was a typical radical lawyer's position. If it was a political trial, a consciously political trial, the defendants set the tone. They were in the driver's seat, and he deferred to that. He had sized Judge Hoffman up as, that is, not to be confused with Abby Hoffman, one of the defendants. Julius Hoffman was the U.S. District Court judge in the Chicago 7 case. He had sized Julius Hoffman up as a man who could be baited and who could be made pushed, and that he would overreact, and this would cause bad image for the government. He later said, Kunstler that is, said, I think the trial might have taken a very different turn if there'd been another kind of judge. But from the point of view of the political education that we intended as a vital part of the trial, Hoffman was the best judge we could have had. His total lack of sensibility, his total lack of a sense of public relations, his total commitment to the conviction of the defendants, all made him commit not only legal errors, but also errors in the area of public opinion. And it was these errors that helped gain the defendants so much public support, particularly among the young. A much fairer judge would perhaps not have enabled the defendants to present as dramatic and convincing a case as they did to the general public. Okay, now getting to the Netflix and my critique of it. There are three areas that I have this little bit different opinion than the the producers of the Netflix. Number one, there were far more dirty tricks on the part of the prosecutors and the law enforcement in the Chicago 7 trial than are depicted in the Netflix film. The Netflix film did show the FBI's forgery of the letter to one of the prospective jurors allegedly signed by the Black Panthers in an effort to get her to quit being on the jury, to say she was afraid to leave. But there were other dirty tricks as well. The FBI actually bugged the conferences between Kunstler and his clients. The Kunstler and Leonard Weinglass, the second in command of the counsel, and the defendants had conferences, and naturally, and they expected, as defendants and lawyers expect, privacy. But no, the FBI not only bugged them and obtained the information about their plans and their strategy, their thinking, etc., but they also shared this information with the prosecutor, just handed it over to the prosecutor. And the FBI also spoke privately with some of the jurors. The FBI also spoke privately with Judge Hoffman. So the dirty tricks were a little more extensive than the Netflix film presents. Secondly, I think it's fair to say that the trial was more disruptive than the Netflix film shows. This I really don't understand, because it could have been kind of, from an entertainment value, a good thing, I think. For example, just some examples that weren't in there. One day, one of the defendants pulled out the Viet Cong flag out of his briefcase. The defense table was cleared. This is during the trial. Judge was there, jurors were there, somebody was testifying. And then they just displayed the Viet Cong flag over the defense table in the federal district court. And of course, that caused uproar, and that led to a fairly lengthy tug of war between the marshals and the defendants who would get possession of the flag. One day, the Netflix film did depict the day that they all entered wearing sort of costumes, but it was a little bit more forceful than what they did, because they wore judicial robes into the courtroom. They all wore judicial robes, and the judicial robes had stars of the Star of David all over the robes. Julius Hoffman was an observant Jew, and undoubtedly that deeply offended him. He was there to see it. The jury was there to see it. And then the defendants took the robes off, threw them on the floor, and wiped their feet on them. So maximum outrage, and of course that got a lot of publicity and attention, which is just what they wanted. And individual taunts. One defendant asked one day, "How's your war stock doing, Julie?" Another defendant said to Hoffman one day, "You're the laughing stock of the world. Every kid in the whole world hates you because they know what you represent. You are synonymous with Adolf Hitler." So that, of course, caused upset. And the defendants themselves, just in the way they conducted themselves, it's not terribly well depicted in Netflix, but they often spent a lot of time at the table, the defense table, reading books, novels. Novels, start reading, paying no attention to the testimony. They weren't on trial, the government. And munching jelly beans, making faces, laughing. Sometimes they just slept at the defense table, just leaned over the table and slept. And Bill Kunstler, it's fair to say, just refused to do anything. And this is why it was so criticized by the prosecutors and the judge too, that as an attorney, he had a duty to sort of control his clients. And Bill Kunstler said, no, I don't. I have a duty to tell them the consequences of some of these acts. And he had warned them that they might be held in contempt for some of these things, but it doesn't have any duty to control them. And so he followed their political line. Kunstler himself engaged in a sharp repartee with Julius Hoffman, Judge Hoffman, a couple times. Some of them are very amusing. Apparently, one of the prosecutors had referred to Kunstler as a phony and two-faced, and Kunstler took umbrage at this, or at least he pretended to take umbrage at this. Mr. Kunstler, you know it is not right. To call a man phony and two-faced in oral argument is not right. We both know that. You don't say anything and you are countenancing the remark. The court. For your information, perhaps you don't know it. The word phony is in the dictionary. Mr. Kunstler, so is the word pig, Your Honor. And of course, pig was the young people's term for police and police law enforcement. And there were countless repartees about whether this was a political trial or not. And Julius Hoffman was always trying to say, no, this is not a political trial. It's based on a specific statute, charged violation with, etc. And there was an interesting repartee about that. Judge Hoffman, it is a criminal case. There is an indictment here. I can't go into politics here in this court. Kunstler, Your Honor, Jesus was accused criminally too. And we understand really that was not truly a criminal case in the sense that it was just an ordinary. Judge Hoffman interrupts. I didn't live at that time. I don't know. Some people think I go back that far, but I really don't. Kunstler, well, I was assuming Your Honor had read of the incident. So that sort of repartee was, it's kind of amusing, I think. It was fairly common. The other thing that I would take umbrage with, as far as the Netflix film, is that the Netflix film gives the impression that at the end of the trial, everything was okay. It was kind of a happy time. It gives the impression that, somehow in some way that people were good spirited about what had happened. But that's not the reality. At the end of the Chicago 7 trial, jury went back to reach a verdict, and the judge then proceeded to lay down his findings of 159 acts of contempt, 159 during the trial. And he gave sentences ranging, in his view, on the severity of what had been done, from ranging on the low side from 2 months and 8 days onto the high side in 4 years and 13 days. Now there was it was the law then and now that if a judge gives a contempt sentence greater than 6 months, there has to be a jury trial on the contempt. But what Julius Hoffman did is all of his sentences for any particular act of contempt were 6 months or less, and then he just made the sentences run consecutively, one after another, rather than concurrently. So that's how he got up to 4 years and 13 days for Bill Kunstler. Now the jury verdict was interesting. I think it's kind of amusing, interesting in any event, to see what the jury did in regard to the two charges that faced all the defendants. The defendants were charged with violating a specific federal statute that made it criminal to cross a state line with the intention of inciting a riot or insurrection in the state in which they went to, and then in that state doing some sort of act, not necessarily itself criminal, but some sort of act that contributed to that uprising or that riot. And they were charged with that, violating that statute. And they were also charged with conspiring, which is an illegal agreement to violate that statute. All of them were charged. Well, all 7 of them were charged with conspiracy. The jury acquitted all of them of the conspiracy charge completely across the board. And then, as to the main law itself, the jury acquitted 2 of them of sometimes the statute is called the Rap Brown statute because it's somewhat directed toward Rap Brown in his earlier acts in the East. But they did acquit 2 of them of the basic statute and convicted the 5 remaining. The 2 that were acquitted were some of the most moderate of all of the people involved in the protests in the trial itself. A fellow by the name of Freunds and a fellow by the name of Weiner. They were acquitted of the substantive offense. So then Hoffman had to sentence them, and he had some discretion in the sentence. The sentence was 5 years, up to 5 years, and up to $5,000 fine. So Julius Hoffman, gave each and every one of the defendants the maximum sentence of 5 years and $5,000 fine. And of course, that is in addition to the contempt charges. And they indicated they were going to appeal. Naturally, they would. Hoffman refused to set bail for the appeal. It's common that except in violent crimes, that a convicted defendant can be bailed on appeal, but Hoffman refused to set bail. The appellate court eventually bailed the lawyers out in a matter of hours. And as to the 5 defendants, well, actually, it was more than 5 because even the 2 that were acquitted of the basic crime had some contempt sentence, not as high. But so all of them were in jail. It took 2 weeks for the appellate court to set bail for them. So at the end of the trial, all of the defendants, except Freunds and Weiner, faced 5 years and $5,000 plus this time for the contempt sentences. And much of that was clear. Well, it was all cleared up in the appellate process eventually. But it's hard to think, for me to think, that it was anything other than kind of bleak at the end of the trial, rather than what the Freunds, rather than what the Netflix movie presented. Now, one curious thing, this is kind of interesting. Bobby Seale benefited from this verdict because Bobby Seale had not been charged with the basic crime, the Rap Brown statute, of crossing the state line with the intention of a riot and then doing something later. He had just been charged straight with conspiracy to do these things. That's all he'd been charged with, just conspiracy. Well, it's not legally possible to conspire with oneself. And since all the other defendants had been acquitted of conspiracy, that necessarily acquitted Seale as well. Okay. Now, I wanted to talk a bit about radical lawyering in general in the 60s and 70s, because it's an interesting phenomenon, and it's also not terribly well known. Hasn't been written about as much as it should be. America has always had political trials. I mean, there's no question the Wobbly trials in 1918 were political in nature. The Oklahoma anarchist trials in the 30s were political. The Communist Party's persecution under the Smith Act in the 1950s was political. But the earlier, before the 1960s, political trials looked like any other trial. the defendants behaved themselves, sat down there, and the lawyers did all that swarmy deference to the trial judge, all this, your honors, and all that stuff. It looked just like any other trial. But the New Left lawyers in the 1960s and 1970s rejected the legitimacy of the legal machinery. They thought the legal machinery, just like every other government institution, was just an effort of the haves to control the have-nots, and this was just one part of the machine. And they thought that, well, they could use trials to score political points about that, and that was what was meant by put the system on trial, to show the oppression of people in the position of the defendants. Or if it was strictly a political, purely a political trial, then to show that they were being persecuted because of their beliefs. So, you know, the attorneys before in the older political cases, the communist cases and the labor cases, and would never have thought of disrupting the courtroom. But if it fit the radical lawyers didn't disrupt every trial, no. But if it fit if they could make it to serve their political motive, then they saw nothing wrong at all with disrupting a courtroom, because it was illegitimate anyway. It's just an oppressive part of the system. Now, Bill Kunstler was like radical lawyers and unlike radical lawyers in some different ways. He had some nuances. In one respect, he was very much like all radical lawyers, and that is he tried to get extensive publicity for his cases. And the reason for that is that the publicity to the outside public was the very essence of getting the political points that he was trying to make across to the public. And Kunstler did this publicity and did work the media much better than most radical lawyers. He was a master at it, but it's very much what the radical lawyers all wanted to do. In one respect, he's unlike the many of the radical lawyers of the 60s and 70s, because he didn't adopt the street clothes of his clients. He wore a suit and tie, maybe threadbone, but sometimes he wasn't deeply concerned about his appearance, but he did wear a coat and tie. And he thought that actually made him more effective with the media. That's what he said, why he did it. It would be easier to take pictures of him, and he might get maybe a little bit better hearing from reporters, but he did wear a coat and tie. Now, Bill was different than most other radical lawyers in that he had this upper middle class upbringing, and in some respects, that stayed with him in some ways. For example, he still read French poetry. Now, actually, he was a very busy guy, and so some of these things he couldn't do as much as he wanted, but he did read some French poetry. He still enjoyed the opera, played operas at home. In earlier days, he went actually to the opera house. In later days, he stayed at home and played the opera. He performed opera in a sense, because he and the produce man at Balducci's, which is a grocery store and delicatessen around the corner from where he lived in Manhattan. He and the produce man would sing Puccini duets together a lot. They're hamming it up. So the radical lawyers of the 60s and 70s were all committed to profound social change. Socialism or egalitarianism of some sort, the elimination of sexism, the elimination of racism, And they thought that, that could be peaceful if possible, but they weren't opposed to violence if that was necessary. Not at all. Kunstler and radical lawyers thought of themselves as participants in the revolutionary struggle. They were not just cool and aloof professionals like lawyers tend to present themselves as. They weren't that at all. They thought of themselves as revolutionaries first, that just happened to be lawyers. And the court system is just another form of government oppression, but they could make use of it. Now, Kunstler, in terms of the revolutionary theory and so forth, fits in somewhat imperfectly because he was more of a man of action, quick to take action against any oppression that he saw, and not a systematic thinker. He mentioned this in a couple rather interesting commentaries. In 1970, he gave a couple interviews that touch on this. He told one reporter that Kunstler had come to the conclusion that capitalism as a system is destructive of human beings and must be replaced. But by what? I don't know. And then later on that year, he said, while a complete reevaluation of our economic system was needed, he could not get into specifics yet because I haven't thought it through. But I do know that to translate this conviction into my own life is very difficult because I'm a completely middle-class person. I have a lot of good things in life. So in general, Kunstler's notion of violence was a little bit more nuanced and probably a little bit more realistic than than most of the radical lawyers. Kunstler thought that violence is really appropriate only at the crest of a revolution, just at the point when the power is about to be transferred, a coup d'etat or something that might involve some violence. That'd be the appropriate time for violence. But to have violence before the crest of the revolution would be counterproductive, because it wouldn't accomplish anything and it would irritate people who could otherwise be persuaded. That said, it also, if he had clients that thought now is the time for violence, that would not have bothered him to represent them at all. They would follow the political line in trial of the clients. Well, again, the legal system is an extension of capitalist oppression, but the radical lawyers thought it had contradictions that could be exploited. And of course, a big contradiction is the one that defendants have a right to be represented, even by radical lawyers, and radical lawyers can make comments in out of court to reporters about what the trial is really about, in their opinion, and they could also try to do the same thing in their arguments to the jury. So you might have a radical lawyer in a particular trial making a very impassioned argument on behalf of the First Amendment, and extolling its virtues, and on and on. But this doesn't mean that the radical lawyer doing this has any particular personal regard for the First Amendment. This is just, he's doing this out of a political motivation. And he's just exploiting a loophole. It's not, in contrast to that, you can contrast that to the ACLU view, where actions of vile people can stand for an abstract good. And if the abstract good is protected by the First Amendment, then it ought to be supported and defended, even though the activities might be quite themselves vile. The classic ACLU example of that is the defense of the neo-Nazis marching in Skokie. What is it that the radical lawyer wanted in a trial anyway? Well, the release of the client was one thing, but that was not by any means the only thing. The other thing, and even more important, was what was called, this is not my term, it was their term, demystification. What's that? Well, demystification is an effort to demonstrate to clients, to the jury, and to the wider public, hence the high regard for media coverage, what the case was, in their opinion, really about, the political realities underlying the criminal cases. And it was either because of the defendant's beliefs, political beliefs, or because they were a member of a class that was oppressed, and so forth. But this extended even to civil cases. For example, I'm now quoting from a sociologist that studied radical lawyers. Through demystification, tenants should come to see tenant-landlord law as fundamentally skewed toward the landlord, while unions should learn that labor law is a tool for managing the capitalist system. Once the class nature of the law is understood, radicals hope that the tenants and labor groups will neither pin all their expectations on court decisions, nor entirely despair over unfavorable judicial outcomes. Thus, radical lawyers might try to encourage such clients and allies to develop extra-legal modes of effective action. Okay, so the idea is to generate a loss of confidence in the judicial system, and by extension of that, the entire government. The Bill Kunstler had one or two judges that he sort of admired, was sort of quasi friendly with, but he, in general, like almost all radical lawyers, he didn't think much of judges. There are just a couple interesting. He was once asked who were the top 10 judges that he knew, and Kunstler he responded by asking whether he could name people who judged the Miss America contest. Then I think a very gutsy remarks in 1993. He was invited to speak at a conference sponsored by the New York Supreme Court Justices, which is trial judges in New York. And he told the assembled trial judges that, quote, "Judges are creatures of the establishment. They do what's politically correct for them. The worst of them are mean-spirited, racist bastards. As for defending the Constitution, they probably violated it more than any other branch of government." So that's Kunstler on judges. But again, we have to be a little nuanced here, because even though this inflammatory language out of court, the in-court conduct of Bill Kunstler was far, far different than what was displayed in the Chicago 7 trial. The Chicago 7 trial turned out to be the circus it became, because that's what his clients and defendants wanted. And it was a political case, and they acted out of political motives, and therefore they should control the procedure. But in the typical case, the Kunstler didn't act like that. I spoke to a lot of people, interviewed a lot of people in writing this book, and I one I particularly want to mention, I talked with, interviewed Judge Jack Weinstein, who's a federal district court judge in Brooklyn. And Kunstler tried a lot of cases before him. And Weinstein told me that Kunstler, in terms of what he was in court, was not only, he was polite and prepared. And he actually liked to see Kunstler walk in with one of the defendants, because he thought that some defendants didn't get really good representation, but he knew this guy would get it with Kunstler. But he said he saved his, what Weinstein called his stump speeches, for the reporters in the corridor. Okay, so the radical lawyers' trials, or a forum for getting out the radical message. They don't have a voice in the legislature. They don't have a voice in the executive branch. But in trials, through their attorneys, they do have a voice, and they thought it was a good way. And the demystification, the showing of the system itself is unfair to Blacks, Native Americans, just as important as acquittal, actually. Acquittal would be nice, but the demystification was even more important. Kunstler's partner, Ron Kuby, told me, quote, "Bill always took cases that he should have lost. But when you lose, the idea is to make the system pay. You erode the public perception of fairness in the case. So people say, okay, the government won, but they won in a loathsome way. You make people ashamed of their government." Now, it's one last point to be made, I think, about radical lawyers, is that they had a very different method of choosing clients than most lawyers do. It didn't have anything to do with whether they could pay the fee. It had to do with the client's political views. Was the radical lawyer sympathetic with the defendant's political views or not? And it's not what they did. If a KKK murdered somebody, that would be rejected out of hand. If a Weatherman, a radical group, blew up a building and there happened to be somebody killed in it, that's fine. They take it on. In the 1960s and 1970s, it was fairly easy for radical lawyers to find politically sympathetic clients. And as the movement declined thereafter in the late 70s and 1980s, it was increasingly difficult, and radical lawyers turned to the notion more and more of objectively political clients. What does that mean? That means a person that is a member of a class that is systematically oppressed by the government, but didn't act not out of any political motive at all. No political motives, but comes from the classes oppressed. Blacks were always subject to government oppression, Bill Kunstler thought. Native Americans became, as time went on in his practice. Muslims came toward the end of his practice. So it really didn't matter what the act that had the defendant had done. It didn't have the average robber, if he was a Native American, let's say, or Black or whatever, the robbery or murder might have absolutely no political motive whatsoever in the mind of the defendant. Yet Kunstler could turn that around to make it appear political because he's a member of a class that's oppressed. Is one historian puts it very concisely. Even though a prosecution may appear to be an ordinary robbery, murder, or shootout with police, and the defendant had no idea whatsoever of its political implications, a radical lawyer might be able to use the defense of the incident to expose capitalism, racism, imperialism, male sexism, economic exploitation, militarism, police brutality, or other political grievances. Once the case is demystified and stripped of the prosecutor's legalisms, the client, jurors, and hopefully the public generally can recognize the case's political context and the oppression it exemplifies. The radical lawyer does not see a court case as a specific act or set of events, but as a mirror or representation of more fundamental underlying conditions. Thus, the conscious motivation of the defendant is irrelevant. A bank robbery or murder could be political or not, depending entirely on the class of the perpetrator. Okay, the Kunstler was very clever in bringing in motivate the political aspects of what ordinarily would be thought of as regular cases, ordinary cases. For example, he told a black jury in the Bronx the police shootout with a black youth was really, quote, about how the police treat young third world people in the depressed communities of our city. In 1968, he argued that the prosecution of 5 young blacks charged with plotting to steal weapons from an armory and blow up various bridges was merely, quote, part of a plan to arouse the public so that it would be willing to tolerate police brutality during the racial rebellions expected that summer, unquote. Both of those cases, the defendants were acquitted. In 1973, when the American Indian militants were charged with illegally seizing federal land, Kunstler argued that, quote, corporate America stands to lose enormously if the Indians ever regain a fraction of their homeland. So the basic, I think, essential difference between the way most lawyers, most judges see their functions and what a trial is about is that a trial is about finding the truth. Because the crucible of cross-examination and whatnot, jury finds the truth. For a radical lawyer, that's nothing to do with it. It's advancing a political viewpoint is the main point of the trial. Now, I did want to mention that if any of you might be interested in how I went about constructing the book, the methods of research and whatnot, and not just this book, all of my books, the organization of them, et cetera, how I chose the topic. I do want to mention that my most recent book, The Joy of Scholarship, Teaching Law and Writing History. It's available on both Barnes and Nobles and Amazon.